Thank you so much for being here for this panel, which is, of course, very timely on the topic of judicial appointments. My name is Jessie Hill. I'm a professor here at the law school. And I am going to be moderating this program, and I'll get to introduce our four panelists in just a moment. The topic of judicial appointments, of course, has once again made a very prominent appearance in presidential politics in the run-up to the current election. With the confirmation of Amy Coney Barrett to the US Supreme Court yesterday, there's been near constant talk of judicial appointments, including so-called court packing or enlarging the courts, also other forms of judicial reform as like those that are being discussed in presidential nominee Joe Biden's proposal for a bipartisan commission to study judicial reform. All of our four panelists today are scholars who have thought deeply about these issues and who also have familiarity with the federal judicial appointments process in general. So I'm inviting each of them, and after I introduce them, I'm going to invite each of them to speak for just about 5 to 7 minutes of prepared remarks, because I want to allow for some dialogue as well as crosstalk among the panelists themselves, as well as Q&A from the audience. This is a webinar format, so the easiest thing, my preference as moderator, is if you would put your questions into the Q&A box. You can put them there anytime, and then I can look at them when I'm ready to take the Q&A. Also, just a note that this webinar has been approved for CLE credit, and we'll be giving you the information about that CLE credit at the end of this session. Okay, so let me introduce my panelists. I think I'll actually go in the order in which I'm hoping that they are planning to speak. So our first speaker will, and I'm going to be very brief, no disrespect, I just want to get to the substance of the presentations as quickly as possible. So our first speaker will be Professor Juscelino Collares. He's the Schott Van Einden Professor of Business Law, Professor of Political Science, and co-director of the School of Law's Frederick K. Cox International Law Center. Then second, we'll be hearing from Jonathan Adler. He is the inaugural Johan Verheij Memorial Professor of Law and Director of the Coleman P. Burke Center for Environmental Law here at Case Western, where he teaches courses in environmental, administrative, and constitutional law. Then our third speaker will be Rebecca Zietlow, who is the Charles W. Fornoff Professor of Law and Values at the University of Toledo College of Law, where she teaches constitutional law, federal courts, and constitutional litigation. And then finally, we'll hear from Ray Koo, who is a professor of law here at the law school, and Laura B. Chisholm Distinguished Research Scholar, where he teaches courses in constitutional law, copyright, and cyber law. So without further ado, I am going to turn it over to you, Professor Collares. Briefly, 5 to 7 minutes. Maybe you can give us a little orientation on judicial appointments in general and what the Constitution has to say about it, and what your thoughts are on the process.
Sure. Thank you, Jessie Hill. Thank you, Ray and Professor Zietlow and John for being here. And thank you for the audience. This is a great, momentous time to be talking about the subject. I thought, with your permission, Jessie, if I could share the screen so I could place a slide. It's just one quick slide that I would like to display so that the audience, many of who may or may not have a background in on this issue may see. I hope you can see. Can you see the slide?
Yes.
Yes. So basically, I'll start. And I was thinking about basically giving some basic comments about the process of picking and appointing judges in general, and then leaving the job of basically going into backing, in greater depth to John and my other co-panelists. Again, beginning with the basics, Article 2, U.S. Constitution Article 2, Section 2, second clause states the president shall nominate by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. So it's a very interesting, very important provision. It comes as Article, I'm sorry, it says here Article 3, it's Article 2, sorry. And it defines, it's an article that defines the specific powers of the second branch, of the one of the two political branches, the executive. So so we can see clearly that Article 2 provides the president the right and the duty, note the reference to shall, right, to nominate judges and justices to the federal bench. With the advice and consent of the Senate language, one deduces that the Senate has discretion in its advise and consent power, regardless of the electoral calendar, right? So from there, one can see that reasonable minds can disagree about how the Senate exercises its discretion in the confirmation process, both in whether and how it affords the nominee a hearing and obviously a vote. Last time around in 2016, I was for Judge Garland being afforded an opportunity for a fair hearing by the Senate. And this time, my position was the same. Now, again, reasonable minds might differ. If you control the majority, you may view it as your discretion, as in the best use of your discretion not to do that. But I believe that that was a solid nominee, and that it would be better to at least afford the nominee, Judge Garland, whom, again, coming from the D.C. Circuit, 97% of the panels they participated, Kavanaugh and Garland together, they voted, their vote was the same. So I thought that both were qualified anyway, and they were deserving, of course, of a hearing. So now, let me make some observations about the process. Now, the hearings and any eventual confirmation vote are directed at the question of the candidate's judicial expertise. It's not only the candidate's judicial expertise, it's his or her temperament, ethical behavior, and of course, his or her ability to be impartial and fair in deciding cases and controversies. Naturally, the vote is a decision of each senator in his or her own assessment of the candidate's qualifications and ability to serve as an impartial, fair justice or judge. So thus, beyond a mere technical assessment of expertise, however, the confirmation process is clearly a political process, right? Where, again, reasonable minds should agree that different policy preferences do play a role, that the Constitution committed the entire process, nomination, confirmation, and appointment, to the two political branches, makes nominations unavoidably political. Yet, this does not mean that the process should be only about politics or how one expects a judge to rule based on one's own political preferences. True, nothing can prevent a senator from taking into account only his or her estimation of how a nominee is likely to rule in case A or case B. But such predictions can be proven wrong. That happens particularly when the nominee, once confirmed and appointed, decides to do his or her job by following the Constitution, the statutes, the judicial oath, and the judicial canons, even when, as a matter of policy, he or she dislikes the outcome of a case. So, beyond the famous law of unintended consequences, a senator would be wise to look beyond policy and also consider a nominee based on his or her ability to function as an impartial judge. Similarly, a president should not be in the business of nominating a hack or a hyper-partisan. After all, once appointed, even previous hacks can surprise you, right? So the Senate can also serve as an important check on keeping hacks off the federal bench too. Having made these considerations, I was thinking of saying something about the process from the perspective of the nominee too. Between White House interviews, FBI investigations, DOJ monitoring of your life during the confirmation process, this is a long process, a process that exposes so much of a nominee's life that our society should, hopefully, that we should prefer that the political acrimony has become so common in nominations recently, especially for the Supreme Court, would be toned down. I'll be happy to answer any questions from the colleagues, the moderator, and during the Q&A. But I would just like to say one basic point on packing. It's very important to say that once one party moves in one direction toward, altering norms or altering rules of the way things have been, you can have the law of unintended consequences invariably happens and it can bite you. So I would caution against that move. But again, that's my position. Thank you very much.
Thank you, Professor Collares. I'm going to now ask Professor Adler to jump in. I know you've written a bit about the topic of judicial nominations and that you have views about this question of discretion, about the question of the role of politics and the sort of history here and the sort of what you might call a back and forth or an escalation. So any of those things that you want to jump in on, 5 to 7 minutes.
I was going to say all in 5 to 7 minutes. Yeah, so I was just going to make a couple points about what the norms have been in terms of how the political branches have sought to alter or constrain the balance of the court, and what we can say about what's happened up to this point, and again, how that might change or not going forward. Now, this concern has been an issue since the founding, right? The idea that the political branches, politicians would like the courts to be in alignment with the judicial philosophy and governing philosophy of the prevailing coalition. And although political parties were not anticipated by the Constitution, we got them very quickly. And the first time we had partisan change and control of the federal government, there was immediate action to address the composition of the courts. And a whole bunch of things at that point in time, which interestingly enough, haven't stuck, never became norms. So for example, we saw efforts to manipulate the formal size of the court for partisan advantage. We saw Congress suspending the operation of the court. We even saw an attempt to impeach and remove a justice because the Jeffersonians thought he was ruling the wrong way. And all three of those approaches, while experimented with in this early founding era, quickly became things that it was decided were not things that should be revisited. So for example, the impeachment of Justice Chase failed not because there wasn't majority party control in the Senate, but because folks realized that was not a precedent that should be set. The practice turned away from that and rather toward viewing the size and composition of the court as something to be driven by more neutral factors. So for example, the tendency has been to expand the size of the Supreme Court historically every time a new circuit was added. The idea was there should be a justice for each regional circuit. And up through the Civil War, that was generally the practice. The exception was during the Civil War and in its aftermath, President Johnson, who was also the subject of an impeachment effort, seats were taken away from the court in an effort to deny him the opportunity to fill seats. But afterwards, it was again recognized that that was not the sort of norm that should prevail. The court was reset at 9 justices, where it has sat ever since. In the 1930s, as folks know, President Roosevelt proposed a set of reforms to, in his words, quote, restore the balance, end quote, of the Supreme Court, a phrase I'm sure we'll hear a lot in the coming months. But it was characterized by both members of his party and others as packing, as increasing the size of the court so as to alter its partisan and political orientation, and it was overwhelmingly rejected. It's not, since then, the practice has not been to not ever adjust the size of federal courts, but it has rather been to focus on changing the size of the courts based on the actual needs of the courts. So for example, lower courts generally get expanded when the Judicial Conference recommends the addition of new judgeships, and there is enough pressure in terms of burgeoning caseloads to actually see that expansion happen. And whatever happens with the Supreme Court, I expect the next Congress will follow through on approving the Judicial Conference's recommendation of, I think it's 70 some new judgeships, including 5 on the ever expanding Ninth Circuit, because there are real needs for more judges in certain parts of the country. And it's generally accepted that when those new seats get created, the party in control at the time is likely to derive most of the benefit from that. So, for example, one of the reasons why President Carter has the single term record for the most judicial appointments in a single presidential term, sorry, President Trump, you did not set the record, that's President Carter's, is because there was a significant court expansion in 1978. Now, the failure to use court expansion as a tool of manipulating the courts doesn't mean the confirmation process has all been nice and friendly. To the contrary, rather, those tools that our norms have accepted as being appropriate to use, agenda control, various means of obstruction, have been used at times very aggressively. And over the past 35 years, we've been in a period that I've characterized as an ever worsening spiral of escalatory retaliation, where small uses of obstruction, small strategic uses of agenda control get retaliated against by ever increasing forms of retaliation and agenda control. But they've all been within this range of tools, things like failure to confirm nominees because of pending elections, as occurred, for example, in 1988 with pivotal nominations to the DC Circuit and Ninth Circuit of Judith Hope and Pam Reimer, or the nominations of Lillian Bevere, John Roberts, and Terry Boyle, among others, in 91 and 92, never acted upon because of pending elections. And as happened to Elena Kagan the first time she was nominated to the DC Circuit in 2000. Republicans did not act on her nomination. That sort of thing has happened with increasing frequency, as has efforts to accelerate the process, as happened when Senate Majority Leader Harry Reid decided to eliminate the filibuster for lower court judicial nominations in 2013 to accelerate the filling of open seats on the DC Circuit. The other constant over this period of time, and I know I'm reaching the end of my time, is that those on the opposite side of these sorts of maneuvers have often wanted to refer to what their opponents were doing as packing. So, for example, Senator Grassley tried to accuse the Obama administration of packing the DC Circuit by doing nothing more than nominating people to open seats and then working with the Senate to remove procedural obstacles to the filling of those seats. PolitiFact fact-checked Grassley's claims back at the time, and I think correctly concluded that that is not what we've ever understood as packing, rated those accusations as false, that what we've understood as packing is perhaps what the Jeffersonians tried to do, and perhaps what the early Federalists tried to do, and what Franklin Roosevelt tried to do, but is not simply using agenda control and obstruction to either fill or leave open seats for political advantage. Now, as a constitutional matter, what I've been talking about are norms, right? What I'm talking about is not constitutional limitations. The question is whether or not we change norms, they can be done so in a way that do not produce additional and continuing retaliation of the sort we've seen over the 35 years. And like Professor Colares, I certainly share the concern that if it is becomes a new norm, that adding seats for the purposes of establishing party control of the court is accepted, not only does that rapidly lead to an ever expanding court, but I think it also magnifies the dynamic we already see, which makes it harder for judicial nominees who are likely to vindicate politically unpopular views to be nominated and confirmed. And so, for example, the dearth of, say, people with public defender experience on the federal courts, federal appellate courts in particular, and the Supreme Court most of all, is the sort of thing that will not be remedied if this is the sort of path we go down. And I've gone over, so I will stop there. Thank you.
Thank you. Yes, and I think that sets us up well for Professor Zitlow's remarks. She has also written about the sort of history of court packing, and maybe we'll address some more points along those lines. Go ahead.
Yes, thank you so much, Jesse, for inviting me here, and to Case Western for having me. Yes, so just to go back, Jonathan's talk about the history here, and I want to emphasize a couple of things about it. First of all, that the expansion of the court, as he noted, that the Constitution requires only that there shall be a Supreme Court. It gives Congress the complete control over the size of the court and other aspects of the court, such as when the court will meet, that the very first example of expanding the size of the court occurred in the Jefferson and Adams, as he mentioned. Another important example, of course, is during the Civil War era. And during the Civil War, you have to understand that there was, that the Republicans who controlled the Congress during the Civil War, as well as President Abraham Lincoln, had been extremely critical of the court because of the court's Dred Scott decision, and that they were very, very suspicious of the Supreme Court in particular as being a pro-slavery court with Southerners dominating the court. And that they expanded the court thus while President Lincoln was president in order to enable him to appoint more members to the court. That when President Lincoln was assassinated and his Vice President Johnson took control, Johnson being an anti-Reconstruction, having a very strong anti-Reconstruction position, that Congress then reduced the size of the court to 7 to deprive Johnson of the ability to appoint when justices died or retired or died. And that they then increased it when President Grant was elected president in 1869. The significance of this is that what we have here is a dispute over fundamental policy issues about the role of government, in particular the size and the function of government in protecting rights. And the same type of dispute occurred during the New Deal era, when there were legislatures enacting progressive laws, regulating workers, regulating consumer regulations, regulating businesses, and many of them were struck down by the courts, with the most notable examples, of course, being during the Depression, the United States Supreme Court striking down New Deal measures which regulated the economy. And that after the 1936 landslide re-election of Franklin Roosevelt, that he's presented the plan that's known as Jonathan mentioned, as the court packing plan, in order to expand the court and replace older justices, or actually not replace, but add justices that would be what he said were sort of in tune with the times. That was a failure. I think it was, historians debate the extent to which it was condemned and whether it might possibly have succeeded had not a crucial ally died that summer. And more importantly, the Supreme Court changed its tune and started upholding New Deal measures. The so-called switch in time saves 9. Another time when there was a major dispute over the size and role of the government and the ability to regulate. So we are in a situation now where I think, again, we have a court of a deliberate plan by Senator McConnell to appoint conservative justices and anti-regulation judges and justices to the court. As he said yesterday, a lot of what we've done over the last 4 years will be undone sooner or later by the next election, but Democrats won't be able to do much about this for a long time to come. So what I anticipate happening is there is a very sort of a movement towards increasing regulation, increasing the role of government to address major issues, including, of course, the pandemic, climate change, the economy, and at the same time, appointment of justices to the Supreme Court who seem inclined to strike down those kind of laws. We'll see what happens with the Affordable Care Act decision that's they're going to be hearing next week. But we have the same sort of confrontation here. So it's similar, I think, to those other periods of time where there was at least a major discussion, of course, during the Civil War, the Congress actually acted during the New Deal did not act, but the courts changed their tune. So I'm not surprised to hear people talking about this expanding the court. There have been other measures that are suggested. Maybe I'm hoping maybe Raymond's going to talk about those, such as, because I'm running out of time, having to do with jurisdiction, et cetera. I will say that during the progressive era prior to the New Deal, there were also jurisdiction stripping measures enacted. There were also some sorts of other laws that were enacted to sort of reduce the powers of the federal courts. One more thing I just wanted to note is that at the same time as some people are arguing, that Republicans are arguing that it would be harmful to expand the size of the United States Supreme Court, they have been engaged in a systematic campaign to enlarge state courts for policy reasons. For example, in Arizona and Georgia, they enacted laws expanding the size of the state courts so that the Republican governors could appoint members and change the composition of the court. And I think that just the bottom line goes to this, that there's always, law is always connected to politics. Politics is always connected to the law. We can debate what norms we need to keep and what we do not. But I do expect there's going to be a very, very pitched battle over the question of whether to enlarge the size of the Supreme Court in the year to come.
Thank you so much. And then finally, we'll move on to Professor Koo. I think after that, we've had a couple of historical perspectives. Maybe you want to continue on that route, but maybe you want to also move us towards something a little bit more of a normative perspective or a contemporary perspective. So please go ahead. Oh, you're muted.
All right, sure. I'll try to do both of those. Thank you all for having me here, and thank you for my fellow participants for being here as well. So the way Professor Kolaris and Adler began our discussion is kind of the talk about this as a political and policy process, as Professor Zitlow then further expanded. I want to emphasize here that part of the reason why both we may find ourselves or feel that this is a unique time is that the kind of policy and norms that we used to rely on were essentially one that other commentators and the other justices in other areas have said, well, we're essentially living in a world of mutual assured destruction, right? That politicians won't play these extreme games because, once they are no longer in office, the other side will see it as a perfectly reasonable opportunity to kind of take their own positions and exact perhaps some vengeance on their part, right? So we try to avoid the most extreme approaches because we know that there is always the good chance that the other side will do the same. That was true for gerrymandering, and it was also been largely considered true for the judicial appointment process. Now, I will say quite clearly, in my view, I think that in both of those instances, we have essentially mutual assured destruction has failed us. That essentially the Republican Party, both at the gerrymandering level and at the Supreme Court level, has decided to assert as much political power as they can under these circumstances, in part realizing that their political position in the United States is fundamentally fragile at this point. So regardless of what we may have thought about the ideology of prior justices and judges in the past, one thing that is fundamentally clear is that the modern Supreme Court, the court as we see it today, is now comprised by a majority of justices that were not only nominated by presidents that were elected by a minority of the population, but also confirmed by a Senate that only represents a minority of the American population. Now, we can debate over, obviously, the merits of a system that does that, but that is completely within the terms of the Constitution and the kind of discretion of the representatives that are there. The real question is whether or not it should be appropriate and considered legitimate by the rest of us. Right. So we've heard some talk about FDR and the New Deal, but also as both Professor Zitlow and Adler discussed too, the Civil War. And what we saw in both of those instances were clearly examples in which the courts especially were seen not only as out of touch because they might have been older, but because they're held to a very narrow ideology that was also clearly, one, not supported by kind of the facts on the ground, and two, that really no longer reflected the large majority of the will of the population. Right? And we're talking about, under these circumstances, protecting disadvantaged minorities or groups that had otherwise been excluded from the political process. In fact, it was just the opposite, right? To kind of entrench white supremacy during the Civil War and Reconstruction, by narrowing the Reconstruction amendments as far as humanly possible, other than to deny that they were even, considered and adopted in the first place. And then in the New Deal, to essentially deny the existence of both unfair labor conditions and an economic crisis that perhaps required either both a national response as well as kind of changing the bargaining power that existed under traditional common law contracts and other kind of workplace protections. So, we see that in elements of the court, especially today. My favorite example, or my least favorite example, is Shelby County versus Holder, right, in which Chief Justice Roberts, who will now have a quite firm majority, was able to say, because of his position on the court, that there is no fundamental voting discrimination based on race that justified the kind of pre-clearance of the Voting Rights Act, right? And what do we see afterwards? Essentially, the fundamental of elimination of essentially 1,000 balloting locations in majority minority districts, as well as kind of very aggressive voter ID and other kind of regulations that have unquestionably disadvantaged people of color, which was the whole point of the Civil Rights Act to begin with, right? So what do you do about that, right? So Democrats, as usual, are kind of fixed between, well, should we just exercise political power, right? And Professor Adler's and Colares have suggested we shouldn't. Democrats shouldn't. There's a value to kind of be playing nicely and recognizing the dangers of this. I call malarkey on that, a la, presidential candidate Biden, Vice President Biden, because, the nuclear missiles have already been launched and landed. And at this point, I forgot her name, our wonderful senator from Hawaii, that anything else would just be plain stupid on the part of the Democrats. Now, that doesn't have to go with expanding the court just for political reasons, right? As my other colleagues have pointed out, Roosevelt's argument wasn't that these justices were ideologically simply inconsistent with the Democratic Party, but that these were justices who were out of touch with the average life of Americans, right? And so his approach was not to say, okay, well, we're going to add lots of judges to be Democrats, but to add lots of judges that actually understood the plight of the American people and therefore the need for federal and state reforms. Right? The Supreme Court wasn't just stopping the federal government, it was also stopping states from enacting these reforms as well. So, to go back to my beginning point, if we see the fundamental problem here is not just an issue of politics, but the idea that the courts are now packed with judges that do not reflect the majority of the American population through a political process that has allowed a minority to kind of impose and nominate all these justices and judges, then the response could be proportionate to that and recognize that we need judges that not only will uphold the Constitution, but won't necessarily reflect a very specific minority ideological approach to that role. So I'll open it up now, and I'm sure we're going to get some interesting discussion.
Yes, wonderful. Yes, we have a lot of Q&A already in the bubble, although I do want to give panelists a chance to weigh in or respond, especially given that Professor Koo set us up with a really interesting proposition that folks might want to agree or disagree with. And I guess thinking about how justified measures like expanding the court might be, Also, I guess the flip side of that is, what are the prospects for de-escalating this fight? And is that even a possibility, or is it just crazy talk, right? So let me just see if anybody on the panel wants to respond to that before I move on to the, go ahead, Professor Adler, to the questions from the audience.
Yeah, just a couple quick points. I mean, one, I think the argument that we have a majority of justices appointed by folks that didn't win the popular election. We should remember George Bush's nominees were nominated after he won, not just the electoral vote, but the popular vote in 2004, and had a higher, actually not only won the popular vote, but actually had a majority of the popular vote, which Bill Clinton did not achieve in either of his elections. Just a few other little things. One, I think for how folks at the time evaluated Franklin Roosevelt's plan, I recommend people look at the report that the Senate Judiciary Committee issued. Roosevelt's party had a 3/4 majority in the Senate, and the Senate Judiciary Committee nonetheless issued a blistering report that newspapers at the time characterized as tantamount to draft articles of impeachment in the rhetoric and strength of rejecting it. I think that's worth noting. On the history, Lincoln was able to transform the court because there were 3 vacancies that were created. Only 1 seat was added, and it was added because we needed a 10th Circuit for California. And so the justice was added in concert with the creation of a new circuit, as had been the tradition up until that point. The last comment I'll make is the concern is that the court would, because it is arguably out of step with the American public and with popular opinion, and I'm not convinced that that's actually true, that it would get in the way of Democratic majorities enacting the sorts of policies they want to do and want to adopt. And perhaps that's possible, but I think it's worth noting, if that is our measure, that the current court up to this point, and up to this point is a hugely important qualification, the Roberts Court strikes down both federal and state laws at a significantly lower rate than did the Rehnquist Court, the Berger Court, or the Warren Court. It also overturns precedents at a lower rate than either of those courts. So in terms of a court that is taking aggressive action to frustrate the will of political majorities at either the federal or state level, or reversing settled law, up until this point, under Chief Justice Roberts, it has done so far less often than its post-war predecessors. Now, if that changes, maybe the nature of that argument changes. But up until now, that has been what we've seen, and it's not particularly close.
Thanks. Does anyone, Professor Collares, do you want to jump
Yes,
in?
Just 2 points on Professor Ku's observation about the fact that majorities in the Senate, the Republican majority in the Senate does not reflect the majority of the American electorate. I think it's quite clear that the fundamental structure of our country, as it was created, is not one man, one vote based. Rather, in both branches, the way you select a president is through an electoral college. The way even the legislative branch was set up was with one branch that is supposed to operate under majority. You get elected to it through a majority vote, the popular vote, and in the Senate, you get elected through a popular vote too, but the representation is on the basis of state. So this notion that the general political outlook or composition of the political branches are supposed to be necessarily representative of the majority of the American people is not really the original design of the country. We were designed as a constitutional republic. So I would say to that, and that's then the point, I think, bringing the issue closer to what happened with Majority Leader Reid's abolition of the 60 vote for appellate court nominees, and then the tit for tat coming back from Senator McConnell, Majority Leader McConnell, after an election in abolishing the 60 vote requirement for nominations to the U.S. Supreme Court. What you have is each time what you see is that the majority abolished the norm, right? And we can keep playing this game unless you might want to structure it in a way where you will draft rules in such a way that the other party will never again win power, which basically means that you are living in a voting democracy in name only.
You mean
This
like
is not
gerrymandering?
this is not what we want for the country. But one thing I will say is that, at least in the case of Majority Leader McConnell, he ran the risk. He basically said, I'm not going to offer, I'm not in favor of that decision, though. Having, I believe Judge Garland should have offered a fair hearing and a vote. But what we saw happening there was Leader McConnell ran the risk of losing two elections, the presidential that came in 2016 and the senatorial, and the majority, it didn't seem to disturb the American people. The American people elected a Republican president and kept the Senate majority. So I do think that the system is working, and I think it's time to walk back from this tit for tat, unless your ultimate goal is to completely destroy the country.
Okay, I just want to notice and I'll see if the other panelists want to weigh in, but just that we have a question along these lines that I think we're kind of addressing. Someone asked, how do we reconcile the protection of a minority from the majority with asking the court to govern based on majority will? So I think Professor Kollaris kind of addressed this notion that it's a majoritarian institution in any form or not. But go ahead, Professor Zitlow, if you want to.
Yes, thanks. That's exactly what I was going to speak to. Starting with the case of Brown versus Board of Education, and during the years that the Warren Court was actively deciding cases that protected rights of minorities, we talked a lot about this counter-majoritarian difficulty, right? That the Supreme Court intruding on the majoritarian processes, and as Professor Kollaris says, that's really, that's how we set things up. But I really feel very strongly that there is a very strong justification for the court to act in a counter-majoritarian way to protect rights of minorities, but not to take rights of minorities away, so that when the court strikes down civil rights legislation, such as in the case of Shelby County versus Holder, I think that's really problematic from this whole entire majoritarian, minoritarian perspective. And I would add, one of the reasons that people are very concerned about the current court right now is it keeps striking down victories of voting rights litigation below, which many cases are being brought in areas where there are a very large number of minority voters and polling places have been reduced, polling boxes are limited, et cetera, on behalf of their rights, and yet the court is striking them down. That's one of the things that I'm very worried about the current court and the trajectory that we're going in.
Thank you.
Yeah, so if I can jump in there. So the concern, right, and one of the ways it's reflected in the way Professor Zitlow described it is, protecting certain minority groups, especially disadvantaged and traditionally, historically disadvantaged groups. And yes, Professor Kollaris is right. The Constitution, as it was originally designed, is not a majoritarian document, but the process itself is often elevated over the form of what it was intended to do. Ideally, the Constitution is intended to serve the public good, right? The 18th century framers believed that this was actually a thing and that the public good was not somehow disembodied and only the amalgamation of individual preferences. They legitimately believed that there were policies that were good for everyone in the society and not just a certain class of people. That has been our struggle ever since the adoption of the Constitution and the American Revolution. Now, this has not been painless, right? The Civil War was the fundamental fundamental recalibration of all of that in its most fundamental form, right? The idea that you could have a master class and a slave class. And we've still been trying to deal with the repercussions of that as it's expanded to women, other people of color, the LGBTQ community. So it's not the preservation of minority rights for the sake of preserving minority rights. And that is the fundamental problem for me in the current process, which is an effort to use the political process in order to entrench your current minority views for the rest of the country, right? Whether it's deregulatory, smaller federal government, or the denial of certain views about corporate citizenship or what is corruption, right? I mean, I've mentioned Shelby Holder as a problem in terms, Shelby County as the problem of saying that, well, that discrimination no longer exists, right? Hear that in every single affirmative action case the Supreme Court's taken since the 1990s, right? Listen to that when it says in Citizens United that the problem isn't corporate speech. Yes, corporations have been given constitutional protection before people were, essentially, or many classes of people. But the idea that kind of paying large sums of money to assist a candidate is by definition not corruption or influencing of the political process in a way that we should find troubling, right? It's fundamental conclusions like that are simply based on a political ideology that are problematic, right? So whether, and so by the way, you know, John likes to point out like the extent to which courts overrule cases, right? I do want to emphasize here, and he was correct to say, look, we've had one truly progressive democratic court, and that was the Warren Court. And that court has essentially been the lightning rod for the conservative movement ever since, right? We have very few courts that have expanded the reach of constitutional protection to protect average Americans, and especially Americans who do not have a voice in the political process.
Thank you. This is a fascinating discussion, but I do want to move on to pull out some of the Q&A. There's some interest in other sorts of ways besides quote unquote court packing to address this issue. One of them is, what is the possibility of reducing Supreme Court terms, for example, to 18-year terms? How could that be done? Is it possible? And if so, someone has an interesting question about who would be able to challenge its constitutionality and who would hear that appeal, that, you know, would the Supreme Court just rule on that question? So I don't know who wants to jump in on that set. Go ahead, Professor Adler.
So if it were done by constitutional amendment, obviously it's easy. The question is whether or not an 18-year term could be enacted through statute in a way that is consistent with the Constitution, providing that judges have their terms of office for good behavior, which since the founding has been understood as meaning so long as they wish to discharge the office. I am of the view that it is probably possible prospectively. That is to say, if it only applies to newly appointed justices, you could not, I don't think you could retroactively impose an 18-year limit, but I do think consistent with the way that other statutes out there, like the Federal Vacancy Reform Act and the like, define the nature of offices as having contingent elements, that the office of associate justice could be defined as 18 years of service on the Supreme Court, resolving merits decisions, and then riding circuit and stepping in cases of recusal after that 18 years, and that confirming someone to that newly defined office, I think is plausibly constitutional and consistent with things we've done in other contexts. Would the court accept that? Good question. Would the court think it's justiciable? Good question. On the one hand, we have the Nixon case, which says impeachment of judges is something that is not justiciable at all. The courts cannot evaluate whether or not a Senate trial was actually fair. On the other hand, when it came to playing around with judicial pay, the courts, and there was litigation in the Federal Circuit, which may even still be ongoing, the courts weren't so quick to get out of that, because if they didn't decide that, then no one could. So I'm not sure the court would accept that. There are other ideas out there that would not require a constitutional amendment. Dan Hemmel at Chicago has an idea that I've been talking about with him, where Congress would create 2 new seats on the Supreme Court every presidential term, period. And so that would have the same number of nominations that you get under the 18-year term limiter proposal without trying to impose the term limit. And so without avoiding the constitutional problem of trying to impose a term limit. And he and I right now are working on figuring out what are all the bad things about that idea. But something like that could easily be done by statute. And then again, if you go the constitutional amendment route, a Pete Buttigieg's 555 proposal, then is something you could do through amendment. I mean, by amendment, you could do anything.
Professor Zietlow, you look like you want to jump in.
Oh, no, I was just enjoying Professor Adler's answer. I guess I would just say that, oh, I did have a thought, and that I can't think of, no, I was just,
no problem. Yeah, we've got lots of Q&A. So did anybody else want to? No, go ahead.
Someone in the chat was making some interesting points about this. And I think that I don't see why we can't have a larger Supreme Court. That's what I was going to say. Why is it such, I mean, the court's only hearing 60 cases a year. Arguably, they get cert petitions for over 4,000 a year. Maybe we need more justices on the Supreme Court. We have 11 circuits now, plus the DC circuit. And why not have at least 12 justices on the court? That's what we used to do, a justice per circuit. I just don't see why it's so sacrosanct. And if it dilutes the power of any particular justice, I say, great. Then maybe we'll have less of this, yeah.
Yeah.
Hey, Jesse, if I can jump
Go
in here
ahead.
for a second.
Mhm.
Yeah, and so I do think like some of the other alternatives out there, like the ones that Professor Adler has mentioned, are great. I mean, there's actually one fascinating idea of kind of changing the Supreme Court into having two specific kind of dimensions and roles, right? One being the constitutional adjudicator, and the other being the kind of statutory adjudicator, and the extent to which we can divide the substance of. The one that I actually am fascinated by is to change the rules of decision making, right? So as I forgot which commentator it was who said, look, in this, when we had 4-4, we got some very interesting decisions from the court, in part because you have to have compromises under those circumstances, right? And there are other, judicial bodies, both traditional as well as constitutional, that have different rules for decision making that aren't simply a majority take all. And so, if, for example, you required a consensus, actually unanimous decisions, the way we do in certain criminal cases, but do that for a Supreme Court review or appellate review, we would have a very different judicial system, and one where partisanship becomes less important, right? And the need to collaborate and to reach agreements plays a bigger role. Though Professor Adler's face is there. Yeah, I've been trying to think through that one too, because it also has some potential downstream disaster that might be there.
It's the difference between the Fifth Circuit and the Ninth Circuit would be much more dramatic under that sort of proposal, right? Because when the Fifth Circuit goes one way, you can't correct it. When the Ninth Circuit goes another, now maybe that's good. I'm partial to the uniformity of federal law norm that the court has embraced, but that's a trade-off.
But may I jump in and just say a couple of things to Professor Zitlow's question about why can't the court just be bigger? Why can't we reimagine this? I think that first of all, that would change. I was a clerk in a constitutional court, and that operates a lot like a legislative or a deliberative body, which seems to be what the court would become if it becomes bigger. And I don't think that, I'm sworn to, for 20 years, I can't make comments about what was exactly said, but I said it changes the nature of the court, especially because what happens is people are constantly talking policy, and people are constantly, they're not reasoning from law to fact, they're reasoning from policy, and it's all political. And I saw things, and maybe this was because it was a different country, but that I wouldn't want judges to turn to. But the point, I think, is I understand that there's this angst and that there's this need or interest in reform. What about a more incremental, the best way, the central problem here is the perception by either side of the need to avoid ideological, problematic nominees. I think the Senate had thought about the formula, or had the formula about that, and that formula was a 60-vote rule for appellate court judges, for Supreme Court, justices. And I mean, we can recall the Justice Sotomayor, I believe, got 68 votes. Justice Kagan perhaps got more, which means a good number of Republicans voted for these people. And this is even after Senator Sotomayor, made some controversial statements like, that seem to deviate from the general neutrality of a judge. You thought that the judge should be empathetic. What happens if you are empathetic against the other party and not for me, and I'm appearing before you, judge? So even that judge got 68 votes. I think that if we went back to that place, we might be much better off. We might have more opportunity for the Senate to return to being, more conciliatory, and we might end up as a process getting judges that are more that stayed more faithful to being impartial and neutral. Thank you.
Great. Yeah. And we actually did have a question about that 60-vote rule. So it was the Democrats who got rid of it for the lower federal courts, right? And then when the Republicans took control, got rid of it for the Supreme Court to get Justice Gorsuch on the court. So just to tie that loop. We only have a couple minutes. I do have one quick question that if we can answer very quickly about how you would go about reducing the size of the court, and could you kick existing, newly appointed justices off the court? Could you move them to a different court if you wanted to shrink the size, or do you have to wait for retirement? So do I have somebody who wants to jump on that? Go ahead, Ray, you're nodding. Or do
you have to wait until retirement. And that is, one of the very important parts of the way the court is structured, right? To in fact, kind of temper some of what would be very clearly excited, energetic, partisan concerns, and about kind of fundamentally altering the nature of the branch of government like that.
Mm-hmm.
I mean, technically, you could impeach and remove, right? But the Jeffersonians walked back from that precipice with Justice Chase. Yes, we've seen symbolic things along those lines, right? As a congressman, Gerald Ford talked about impeaching Douglas from the court, but that never went anywhere. It was understood that was kind of, that was a political gesture. That would be the only way.
And the political move to same thing to impeach Earl Warren, right? I mean, the concerns about the justices like that being out of step.
Yeah. Thank you. So we are at 12:59. I want to turn it over now to Eric Seiler to give the CLE info before we close and thank everyone. Are you there? Oh, there you are.
If you why don't you just go ahead and close real quick, and then I'll give the CLE information.
Oh, okay, well, great. Well, thank you all for being here. Thanks to our panelists who've done a wonderful job. I thought that was an incredibly vibrant conversation, and of course, it's not anywhere near coming to an end. I think it's going to continue for quite a while to come. So, thank you all. I'm sure the audience is virtually applauding, and sure, turn it over to you now, Eric. Thanks.